Hello, Colorado Realtors. I'm Scott Peterson with another edition of Legal Bites. It's been a while and I look a little different because I've switched from a goatee to a mustache.
Hold on, kid. Get back here. What are you doing? You're trying to put me out of a job. Enough of this business, you little turkey. No pun intended. Hello, Colorado Realtors. I'm the real Scott Peterson, and my imposter, Jacob Panzer, was just here trying to dispense some legal advice. He's not even licensed. He looks like he could be, but to my knowledge, he doesn't even have a license. So we'll just delete that whole section, I'm sure. All right, guys. Well, welcome back. It's been a little while since I've done Legal Bites and been busy. I've been getting around the state a lot and seeing a lot of you folks in person and doing classes and local association visits, and it's been fantastic getting back together in person. I hope you guys, at least some of you, were at the 100-year celebration that we had down at the Broadmoor a few weeks back. Beautiful event, really, really well attended and a ton of fun. So despite the fact that I haven't been here in the studio, I've been able to get out and see some of you folks. But hey, it's time to get back to work. Holiday season be damned. I'm going to be back here doing a couple of legal bites that will be rolling out between now and the new year. The first one that I'm going to do is on post-closing occupancy agreements and some considerations that I want you guys to be thinking about as you are engaged in drafting these things, hopefully drafting them and not just having some agreement to agree to a post-closing occupancy scenario, because that's where we get into a lot of problems. But you guys, we've been seeing these for the last, 2 years, 18 months, 2 years, since we've seen this really high velocity, low inventory market. One of the concessions that buyers are invariably willing to give at the time of contract in order to help induce the seller to accept their offer is a pretty loose, liberal, open post-closing occupancy leaseback to the seller so that they can, maybe close and transition into their new home, or they have time to make, to take the proceeds from their first sale and apply it to their second. Whatever the case may be, the market is forcing a lot more of these post-closing occupancy agreements. And because of that, I've been seeing over the last many months a real spike in issues. And here's the deal. Again, buyers are happy to agree to anything at the time of contract in order to get the property under contract with the seller. But then they get under contract and they start feeling pretty proud and happy about the fact that they've got this property under contract. They get some more parity, a little bit more parity in the negotiation position, or in some cases the seller throughout that transaction really bangs up on the buyer because they can, right? They're not giving any seller concessions, they're not doing inspection resolutions. And then we get towards the end of the contract period, much closer to closing, and the parties haven't really worked out any details with regard to post-closing other than maybe, hey, it's going to be 15 or 30 days or maybe 60 days. But they don't talk about rent, they don't talk about security deposit, they don't talk about any other specific terms that would be in the post-closing occupancy agreement, and they're supposed to close in a week or two. Well, that has created a ton of problems, a ton of disagreements, because I don't know who's right. So this concept of really easy negotiation by the buyer at the time of contract, or no negotiation whatsoever by the buyer at the time of contract, is a terrible idea. So if you're going to be using post-closing occupancy agreements, and I get the necessity of them, the first thing I'm going to tell you is get one. Do the actual document. Now, I do get a lot of questions about, well, they're going to be in the property for an extra day. Possession's going to be delivered the day after closing. Well, remember, the more time that intervenes between closing and delivery of the property to the buyer from the seller, the greater the likelihood that things can go wrong. And the purpose of that post-closing occupancy agreement is to address or to apportion rights and responsibilities and liabilities for when things go wrong. So if we're talking about possession the next day, I'm not going to fall on my sword and tell you to get a post-closing occupancy agreement. 2 days, 3 days, 4 days, the longer you go on, the more important one of these documents become. But here's the second piece of this is make sure, and I don't care whether you're representing the buyer or the seller, hammer out the terms of the post-closing occupancy agreement in the contract or at the time of contract and attach that post-closing occupancy agreement. Don't, this language of, seller agrees or a buyer agrees to allow seller to remain in possession of the premises for, up to 15 days after closing, that just doesn't get you there. because as you get towards the end and when closing is getting closer to occur, the buyer's now like, well, wait a second, I would like some rent payments, or I would like a security deposit. And you've got a seller who's going, I'm not going to pay rent to stay in my own house that I've been living in. I'm not going to pay a security deposit to secure the condition of the property that I've been living in up to this point. So invariably, this headbutting occurs, and I never know who's right or wrong. There's not an easy answer. So that's why I say it benefits both the buyer and the seller to hammer out the details of any post-closing occupancy period at the time of contract. Things change, emotions are much higher, and tensions are a lot more frayed the further down you get in the contract. Remember, the post-closing occupancy is, in my view, just kind of a bad lease. I mean, that's all it is. It's a residential lease agreement between the seller as a tenant and the buyer as a landlord. But the other thing I want to mention here is that comes with some important consequences as well, including the idea that if a seller is not delivering possession at the end of the post-closing occupancy agreement, the remedy for the buyer, the landlord in that case, is going to be going through the eviction process. And this isn't going to be a video about COVID evictions, but I think we all know at this point in the history of our market how difficult it is and how time-consuming and expensive it can be to obtain an eviction in this world. Now, a seller's going to have the penalty for delayed possession in there and some additional damages if they're not turning over possession of the properties. But still, in order to get a seller or a tenant physically out of a property, the one way to do it is going to be an eviction if they're not going to do it voluntarily. So unfortunately, that's the kind of realm you're dealing in. The last thing I want to mention on this topic is this. The security deposit that occurs for a post-closing occupancy agreement is meant to secure or to protect the buyer, landlord, from damages that occur to the property during the post-closing occupancy period, during the lease term. So this is meant for from closing until possession is actually delivered is what that security deposit and damages that may occur during that period. This is not for stuff that the buyer didn't notice or see at the walkthrough or prior to closing. This is not for changes in the condition of the property during the contract period. It's only for the post-closing occupancy period. So the important takeaway here, if you're a landlord slash buyer and you think you want to hold or offset the tenant's seller's security deposit from the post-closing occupancy period, it needs to be for things that occurred during that post-closing occupancy period, not for stuff that you missed during the contract period. And remember, if you don't account for and return any unused portion of that security deposit and you wrongfully withhold it, then there is a possibility that a seller tenant could go after the buyer landlord for the treble damages as a tenant has against any landlord in the state if there's a wrongful withholding or failure to return the security deposit. So be very careful if you're a buyer or if you're representing buyers in them determining that they're just going to withhold security deposit to offset damages that they can't necessarily attribute to the post-closing period. So be mindful of that as well. Anyhow, bunch of issues with that. If you have more derivative or nuanced issues, the Car Legal Hotline is available from 9 to 12 and 1 to 4 Monday through Friday. Always love hearing from you there. Have a very, very happy Thanksgiving holiday period here. And like I say, I'm going to kick in a few more of these legal bites for the month of December because we've been getting some requests to get more information out there for you, and that's what I'm supposed to be doing. So I better get to work. Bye, guys. We'll see you soon on another edition of Legal Bites.